from the patent standpoint, it's very important to understand that, the patent system is designed that, if you file for a patent and you are issued a patent with the U.S. Patent and Trademark Office, that you get exclusivity over that idea, how to make, manufacture, sell that concept as it stands within the bounds of the patent application or issued patent, hopefully, that you're the only one that can do that unless you authorize someone else to do that. One of the main things that I tell people all the time is intellectual property is only as valuable as you enforce it, which is an important concept to remember. But, the disclosure period, you get that 20 years of exclusivity, but if you have shared that product in the market publicly, if you have sold it, if you have pitched it, in a more of a public concept, like this goes back to science fairs, and they've put that out in public view. So if they don't file for a patent within a year of that, you are barred from getting a patent on that concept as it stands. That gives you that starts the clock on, you can go talk about it, sell it, get it made, go shout it from the rooftops, share it on social media. A lot of times we'll work with early stage founders or inventors that are like, oh yeah, I showed my product at a trade show, or, I put it on Facebook or made an Instagram video showing, what it is, how it functions. That's also considered a disclosure.
And the stage at which you can file for a patent is what's called reduction to practice. And reduction to practice is kind of vague, but essentially is if in this disclosure that Kate's talked about here, you have 1 year from that disclosure to file the patent, or you lose your ability to file the patent. You have 1 year from that date to file a provisional patent, or you are barred from being able to file it, and you lose that protection. So
it's such an important date to know about, or,
yes.
or concept or principle to know about, because it's one of those things I wanted to put on a billboard, because it's so important. Because what can happen is you're so excited about it, and you're trying it and you're testing it, and you don't necessarily know about the patent process, and you had a really cool idea that was totally patentable, that could have added a ton of value to your business, and you just didn't know what you didn't know. And that's just frustrating, because ultimately intellectual property adds value to your business, adds value to your company.